It was urged that order granting leave should be revoked on this ground itself. It was further stated that there are no disputes with respect to the ownership or management or shareholding of the Indian company. It also took the stand that the plaintiffs are neither the shareholders nor the directors of the Indian company, and therefore they had no right to sue, and consequently the suit itself is not maintainable. It also averred that the disputes between the plaintiffs and defendant numbers 3 to 7 arose around 2013, and the suit had only been filed in the year 2018, and consequently the suit was barred by limitation. Another objection was that the plaintiffs had filed the suit when private equity investors had shown interest in purchasing shares of the Indian company, and the same was an abuse of process of law. Maintainability of the suit was also questioned on the ground that it was barred by Section 89 of the Companies Act 2018 and Section 187C of the Companies Act 1956. Somewhat similar stand was taken by other contesting defendants in support of the prayer for revoking the leave and to rejecting the plain in CS number 33 of 2018. Defendants number 2 also took the plea that it was not interested in seeking the relief claimed in the plaint, which defendant number 2 is the beneficial interest holder of 6% of shares of the Indian company. Counter affidavits were filed by the plaintiffs with respect to these applications, reiterating that they had the locus, that the suit is within the period of limitation, that the court had jurisdiction to adjudicate the issues, and that the suit had been filed with bona fide intent. The learned single judge dismissed the applications filed by the defendants seeking to revoke the leave granted to institute the suit and to reject the plaint inter alia, holding that the allegations pertaining to fraud would have to be decided in the suit. He further observed that there were factual issues that were to be gone into, and sections 187C and 89 of the Companies Act, which may bar the reliefs but would not bar the suit. The aforesaid order of the learned single judge has been reversed by the division bench wide common judgment dated August 3 2018. It has allowed the appeals filed by the contesting defendants and set aside the common order of the single judge, thereby revoking the leave granted by the single judge in the case. Stop.